This morning we filed a lawsuit on behalf of STOP, VFAD, and the three proponents of the initiative against the city clerk, the city council, and the city in response to their recent rejection of the Arena Initiative petition. The case has been filed and it's been assigned to Department 31, Judge Michael Kenney, and we are now working on getting an ex parte hearing date, which is the initial hearing, hopefully as early as Monday or Tuesday of next week, to then set a substantive hearing for mid to late February when these matters can be dealt with on their substance. In a nutshell, the lawsuit is saying that the city has committed an error, omission, or neglect of duty by failing to certify the petition as sufficient now that the county registrar has determined that the petition had over the minimum number required to qualify the measure for the ballot. The city, unfortunately, is seeking to disenfranchise some 23,000 signers who are merely exercising their constitutional right to have this measure on the ballot. Our filing of the verified petition for writ of mandate today seeks to stop the city of Sacramento from shredding the fundamental democratic and constitutional rights of tens of thousands of Sacramento voters who have lawfully petitioned their government for a redress of grievances and the right to vote on hundreds of millions of dollars of proposed city subsidies for private parties. This case is about protecting basic rights under the First Amendment to petition government and under the state constitution. The city is engaged in a sustained pattern of conduct designed to undermine and defeat the voters' civil and constitutional right to vote on this important measure. The California Supreme Court, in the 2006 case of Costa versus Superior Court, very clearly ruled that minor errors in the printing of initiative petitions cannot be used by government as an excuse to disenfranchise voters when the errors were unintentional and, as a reasonable and practical matter, had no impact on the decision of the voters who signed the petition. The city must obey the law and place this measure before the voters, and we seek to require that via the courts. If you look at them individually or collectively, and you look at the impact they may have had on voters signing the petition, is the other side going to be able to show that voters were misled and thought that this was to save the whales, or that this was to bring a baseball team to Sacramento or something else? No, the measure is clearly called the Voter Approval for Public Funding of Sports Arena Act. It's only 3 very short paragraphs, and the official title also includes that reference, where the city attorney entitled it in all capital letters, basically paraphrasing what the proponents entitled it to be. And so that was initiative measure to prohibit the city of Sacramento from using general fund money for the development of a professional sports arena. So either individually or collectively, we believe there was no misleading, no deceiving of the public. Anyone who felt remorse after having signed it could have withdrawn their signature, and at the end of the day, there were more than 10% of the number of voters of 22,000 who signed out of the 220,000 registered voters, and that speaks volumes as to the public's support to get this measure on the ballot. It should also be noted that all we're seeking is democracy, the right of the people to vote on a measure. That measure gives the voters an additional right to vote before public funds are spent on an arena. Nobody here dislikes basketball, dislikes the Kings, or dislikes the possibility of a stadium. It's all about the right of the voters to decide when public money is spent.